Start. In the earlier suit being SCC, suit number 77 of 1980, petitioner had filed written statement. In the said written statement, it had been pleaded that apart from Kashi Ram, plaintiff, his brother Sagar Mal was also owner landlord of the property in dispute and suit was bad for non-joinder of necessary party. The earlier suit was dismissed for eviction on the ground that entire arrears of rent had been deposited by the tenant on the first date of hearing. Kashi Ram, who was also plaintiff of the earlier suit, was permitted to withdraw the amount deposited by the tenant. Against the said judgment and decree, Kashiram, plaintiff landlord, filed SCC revision number 62 of 1982. The revision was dismissed on 15/9/1983 by ADG Special Judge Muzaffarnagar. In respect of question of denial of title, it was held in the said judgment by the revisional court that the allegation of the tenant in the written statement that plaintiff alone was not the landlord amounted to denial of title. Para. However, it was further observed that as denial had taken place during the pendency of the suit, that is, in the written statement, hence, eviction on the ground of denial of title could not be sought for and granted in the same suit. It was further observed that landlord could file a fresh suit for eviction on the basis of the said denial. In view of the said observations, latter suit for eviction giving rise to the instant writ petition was filed. In the second suit giving rise to the instant writ petition, tenant pleaded that he had not denied the title of the landlord Kashiram. Tenant further pleaded that as landlord refused to accept the rent, hence he deposited the same in the earlier concluded suit. Tenant on 28/8/1984 also deposited the entire amount of rent, interest and cost of the suit and claimed the benefit of section 20 under bracket 4 of the act. In respect of denial of title, JSCC held that the assertion of the tenant in the writ statement filed in the earlier suit that Kashiram alone was not the landlord did not amount to denial of title. In respect of deposit of rent made by the tenant in the earlier concluded suit, trial court held that the said deposit was valid and in view of this tenant was not defaulter when notice terminating the tenancy and demanding the rent was given by landlord to him, that is, notice dated 1/2/1984. In respect of benefit of section 20 under bracket 4 of the act, the trial court held that the deposit was made by the tenant after the first date of hearing, hence he was not entitled to the benefit of section 20 under bracket 4 of the act. The trial court therefore dismissed the suit on the ground that there was no denial of title and notice of termination of tenancy and demand of rent was invalid as at the time of notice tenant was not defaulter. The trial court therefore dismissed the suit and permitted the landlord to withdraw the amount deposited by the tenant over.